are in listen-only mode.
Good morning, everybody. Thank you for joining us online today for this morning's webinar. Today we are looking at criminal offences in construction, so a brief guide to prosecutions. My name is Katie. I'll be looking after you today as the moderator for this event. So any questions or queries that come up during this morning, I'll be able to assist you. You can get in touch with us throughout the webinar. It's an interactive session. You'll see on the right-hand side of your screen, you've got a question pane, and what you can do is just type in text-based questions to us, and we'll either address the questions as we go along, if we can slot them in, or we'll look at them at the end. But again, feel free to send through as many questions as you wish. You can find us on Twitter. You can follow us, #CABECPD. Your presenter, it's Kevin Blunden, Deputy Chief Executive for CABE. He looks after all the technical matters and is the man in the know. So, without further ado, I'm going to hand over to Kevin, and he will talk you through this morning's session.
Good morning and welcome to today's webinar. We're going to be looking at criminal offences within the construction sector and how they may impact on you and the work that you carry out. Hopefully everything will run smoothly, and if we have any questions, as I say, type them in and we'll deal with them as we go. We'll do a mopping up session at the end, and if you're having any technical issues, put those into questions as well, and Katie will pick them up as we go through. So we're going to look briefly at the sort of areas that you might end up involved with a prosecution in the construction sector, as well as trying to look at it and decide what's involved, what legislation applies, and how we might actually be looking at a level of fines, criminal offences having occurred, and how the process will generally work. So to start off, let's look at just an illustration, if you like, of how wide-reaching the construction sector actually is, and within that sector what we're actually likely to see as an impact in the wider industry, because at the end of the day we do find that construction impacts on an awful lot of other sections of the economy, a lot of other areas of work, and as a result there's a lot of information that's out there around how prosecutions will occur. So I'm just starting with a simple little case to show the wider picture. This isn't something that's necessarily a direct construction prosecution, but it is just an example case study where the waste from a construction site wasn't being dealt with appropriately. It was being put into an illegal dumping site. Over a course of a period of around about a couple of years, nearly 200,000 tonnes of material was dumped illegally. The people running the tip site were sentenced, one of them certainly was sentenced to prison and ordered to pay costs towards the prosecution, and a confiscation order because of profits earned from illegal activity, and one of the others involved was also ordered to repay proceeds of the crime. This particular issue, because it was about illegal dumping, was dealt with by the Environment Agency, but also dealt with secure orders under the Proceeds of Crime Act to get the monies that were earned as a result of offence back, so that nobody profited from the crime. Now what I'm going to do before we move on too much further is ask you a few questions relating to your involvement, so I can judge where we're pitching this webinar. Now, to be fair, sometimes when we run a poll they work really well. Sometimes the technology swapping screens backwards and forwards causes us a few issues. So we're going to start with the first question, which is about, have you been involved in a project where there was a prosecution? So if you could simply just say yes or no and submit your answer, then once I've got a reasonable response from most of the people involved in watching today, then we can sort of move on, and it helps me to then pitch where we're looking at. So we've got, most of you have actually responded. I think we're pretty much there now, so I'll close that poll and hopefully now share the results with you. This is the bit where it sometimes works, sometimes doesn't. And this is the sort of feedback we're generally getting across the industry is, although there are prosecutions out there, there are headline cases, the vast majority of people involved in the process haven't directly been involved in those cases, primarily because the industry uses prosecution as a tool of last resort. And to get to situations that comply legally with whatever standards we're looking at, there's usually a negotiation process involved before that, an education process, and a period of debate to get somebody into a compliance situation. Most of the enforcing authorities across the construction sector take the view that a prosecution really, unless there's been some flagrant disregard for legislation, is sort of a last resort. So let's see if this bit works. That's where I'm supposed to hide the results of that poll. There we go, that's dropped back. But I'm immediately going to drop into another question. I'm going to ask 3 on the trot here, to be honest. So the second question is, of that percentage of you who have been involved, what role were you playing within the prosecution? Were you acting for the, oh actually there's some spelling mistakes on there, apologies for those, some T's missing. Were you acting as the defendant or acting as a witness on their behalf? Were you acting for the prosecution? Were you acting as an expert witness, which pretty much puts you in there as an independent party just giving a view, or were you involved in some other way? Now obviously I'm not expecting everybody to be voting on this one because the vast majority said you hadn't been involved in a case, so I'll close that one off there and share that result with you as well. And therefore we can see that a lot of you have either been acting on behalf of the prosecution, working with the authority, taking the prosecution, or as their witness, or as an expert witness. And the good news, I suppose, is that none of you have found yourself on the wrong end of these prosecutions. That's got to be reasonably reassuring. Right, let's see if I can now get that back to where we were and then manage the third and final question, which is about the legislation you tend to deal with. So which of these sort of subject areas do you tend to deal with on a regular basis? And you can here select more than one answer. So you can tick everything that applies to you, and it just helps then for me to pitch roughly where we're looking at, what sort of legislation, where the emphasis is. Okay, so the results are rattling in on that one. Okay, most of you have probably voted round about now, so let's just close that one and share the results with you. And this, to a certain extent, enables me just to place the emphasis on what I've already planned for today's webinar. So the vast majority of you have been involved with building regulations. Obviously some of you deal with planning, some of you deal with fire safety legislation, and that's not particularly surprising because those 3 areas tend to have a sort of a synergy and an overlap. About a third of you have had some dealings with the CDM regulations, and then the rest of you are dealing with the vast array of other legislation that is out there. So if I can get the slides to hopefully move on. There we go. Let's look at what I'm going to try and focus on today. Now obviously I can't pick up all of the regulations that apply across the whole board for everything, so I'm going to just move on and look at some of the things we're looking at today and the sort of structure of the legislation and the key areas that I'm going to focus on. So most of our criminal offences are as a result of statute law, acts of parliament, regulations, legislation that generate criminal offences, and obviously alongside a lot of this criminal activity in terms of prosecutions, people who have suffered harm may well be looking to either seek compensation through the criminal processes or to take parallel civil action to get some recourse. And quite often some of the prosecution side of things may well deal with the guilty parties, but might not deal with any form of recompense to those who've been adversely affected by what's happened. So in reality, we're looking at a situation where the sort of areas of legislation we're dealing with are things like corporate manslaughter, obviously fairly headline stuff, fairly major cases, major implications if you're involved in one of those cases. The construction design and management regulations with its regime of prosecution if we failed in our management of health and safety issues. Fire Precautions Regulatory Reform Order, which obviously deals with issues arranged around fire safety of premises once they're in operation. And also planning and building regulations dealing, if you like, with the control of development. Those of you who have been watching closely and have picked up everything will have noticed that I've just turned off my webcam, partly because there's only so much of me you can take on a day, and also because I've noticed that a couple of people have said that they're having difficulty sometimes with the audio. So if you turn off viewing webcams and I turn off my webcam at this end, it might give us more bandwidth for the audio to work a little bit better. Right, so let's start looking at some of these things in a little bit more detail. Recently, there's been some revised guidance issued to the court system to deal with prosecution of health and safety or corporate manslaughter cases. In general terms, the likely sentence and fine that may come out of a prosecution is related to how we got to that point, if you like. So it's very similar in real terms to something we do a lot in the construction sector, which is a risk assessment. So the view that the court will tend to take is, how serious was the harm that resulted from whatever it was that didn't meet legislative requirements, or how serious was the potential harm that could have resulted? And then the other bit at the other half of that coin, if you like, is the likelihood of that harm actually having occurred. So those are two of the factors that the courts will consider when looking at what the appropriate sentence might be. And then the other two factors that really play into this situation are the size of the organisation that's guilty of the offence, and also the culpability, particularly, you know, was this a flagrant disregard for the legislation? Is this a repeat offender? Or actually was this just an unawareness of the requirements or a genuine mistake? Now, you'll all have heard the phrase ignorance is no defence, and that is the case, but obviously there has to be a balance with the courts in terms of cases where people just didn't really know what the requirements were or didn't deliberately breach legislation, as opposed to a differential with those individuals who have deliberately acted contrary to the law. And certainly a lot of organisations, when considering taking prosecutions, will consider whether they can get to a similar resolution by any other means, and will normally only look at prosecuting those people who've flagrantly breached the legislation or are repeat offenders, to try and make sure that we can try and keep things a bit more proportional in real terms. So let's look at the sort of headline issue, the one that, you know, focuses the mind a little bit. Corporate manslaughter, as far as it applies to the construction sector. The legislation dealing with corporate manslaughter offences and changing the remits came into force in 2008, and it identifies where there's a criminal liability of a company or an organisation where they failed in the management of health and safety, if it results in a fatality. So when it comes to a prosecution, the prosecutions are of the corporate body and not necessarily individuals, but at the same time, the directors, the board members, the responsible people within that organisation are also liable under health and safety law or general criminal law as well. So in essence, the prosecution would be against the corporate body, but the directors and the board will carry responsibility, and corporate bodies and individuals can still be separately prosecuted for health and safety offences. One of the issues obviously with corporate manslaughter is because it is dealing with issues where fatalities have occurred, some of the penalties can be quite high. Now in reality, I've put in a few case studies around some of these bits of legislation to give you an idea of the sort of thing that might occur in terms of fines. So this particular first case is, unfortunately, if you read a lot of the technical press, quite a frequent flyer in terms of incidents occurring on construction sites, where somebody carrying out a maintenance project or part of the work before the building is completed falls through a fragile roof or an aperture in a roof and either suffers a major injury or potentially a fatality. This particular case, somebody died as a result of falling through a roof. The firm pleaded guilty to corporate manslaughter and to a breach of Health and Safety at Work Act. The company was fined $200,000 for the corporate manslaughter and $20,000 for the health and safety breach. The owner of the company, who also pleaded guilty, was sentenced to 8 months in prison, suspended for 2 years, and 200 hours unpaid work. They also had to publicise the event, and as with most successful prosecutions, they were ordered to pay costs in relation to the actual prosecution. So quite a severe penalty. Another example, again, of corporate manslaughter, where an employee was carrying out some work and a large block of stone fell off of a lintel and crushed him. The company was found guilty of a gross breach of its duty of care, and they were successfully prosecuted under the corporate manslaughter provisions, and they had to pay just over £87,000 costs and £150,000 fine. So we are talking significant amounts of money. But I think the key to remember there is that the corporate manslaughter prosecution may be running alongside prosecution of individuals or other prosecutions for breaches of other legislation. Right. Other stuff that's in the headlines: construction design and management regulations obviously changed last year. They're made under the Health and Safety at Work Act, and they put key responsibilities of everybody in the construction process, but obviously specific duties on owners, designers and contractors. And you'll have heard a lot in the press about the role of a principal designer and a principal contractor, but everybody in the process has a degree of responsibility in relation to health and safety. So what the CDM regulations are broadly looking for is for the work to be planned to avoid risk, also that the risk can be managed, that the right people with the right skills are carrying out the work, that there's a degree of coordination and cooperation between parties, and that everybody in the process is involved in consultation and assessing the risk and looking after the health and safety of themselves and others. So again, we have to see how this impacts and what we're likely to see in terms of fines. So a couple of case studies. Again, sort of case that we're probably unfortunately all too familiar with. Somebody working down a trench that collapses onto them because it's inadequately supported. In this instance, the contractors and the owners of the property were prosecuted. The owners were found guilty and fined £65,000 in order to pay just over, well, nearly £35,000 in costs. The director of the contracting company that employed the worker was prosecuted and ordered to undertake 270 hours of community service. And that, again, because of the details of the case, was the court considering who ultimately had the responsibility here in the process. So when working with clients, it's important to advise them, particularly under the CDM regulations, of the potential if they don't fulfill their obligations legally, not only on the professionals they're seeking to get advice from and the people they contract to carry out the works on their behalf, but on the owner themselves. Second case there, somebody working in a loft space fell through the plasterboard ceiling. Obviously, there wasn't sufficient provision for walkways or what have you while the work was going on. In this case, the worker didn't actually suffer particularly significant injuries, but the employer was fined £6,000 plus costs because they didn't take suitable action, such as using platforms or covers or dealing with holes in the loft floor. So in reality, something that probably we've all done during our career, gone up into a roof space, walked around on floor joists to carry out a survey or an inspection or what have you, potentially the way in which that's done can have a knock-on effect. And it's not just obviously the contractor and the contractors doing the work, it's the professionals visiting the site and the risk assessment of how those professionals work from an employer's point of view. And that is quite an important issue. I mean, I think those of you, obviously a lot of you have said you're dealing with building regulations. you know, it was common 20 years or so ago that if somebody went on site to inspect the suitability of your foundation excavation, they probably jumped down the trench and had a bit of a dig around to see what the ground conditions were like, particularly to look at load bearing, but also to establish if there are any areas of fill. Nowadays, because of the requirements to the recognition of the need to emphasize bits and pieces, we need to then look at how in reality we support trenches, and therefore people don't necessarily go down if it's a quick process of deep trench fill and backfilling. Okay, I'm just going to take a brief pause while I go consult with Katie. If you can still hear me, please bear with me. Right. Apologies then to anybody who can still hear me for that short brief break, but I understand that we've possibly lost our connection, although some people are telling me that they can still hear me. So I'm going to carry on regardless. I may well be talking to myself, in which case hopefully people will pick this up as a recorded webinar, but thank you for at least confirming, some of you, that you can still hear me, in which case I think it's possibly the message I got was from Katie saying everything had gone pear-shaped, and I think it's possibly just the case that Katie can't hear me. Thank you. Now I'm getting flooded with messages that you can still hear me. I'm not sure, as I say, from your perspective whether that's a good or bad thing, but at least I'll carry on regardless. Okay, so moving on to the next sector of legislation that I wanted to have a quick look at. Let's see. Let's have a look at the fire safety legislation and the regulatory reform order that's there. Okay. The Fire Precaution Act 1971 sets down the basic issues in terms of fire precautions. The regulatory reform order, when it was introduced around about 10 years ago, really looked at replacing a whole raft of previous legislation and focusing the responsibility for fire safety of premises once they're in use. So building regulations deal with the fire safety during design and construction and setting standards. The regulatory reform order takes that building and then puts it into use and puts the onus on the person in charge of the property, the owner or their representative, to actually risk assess what's going on, and as a result make sure that we have a safe situation in practice. Now that may mean that some of the practical bits that are included in the property on a day-to-day basis might not be the same as you'd find in British standards or building regulations, but if they work and they're acceptable and they are a safe situation, that might be a way of demonstrating that the property is being correctly managed. It does mean there has to be a risk assessment. The person who's responsible under the legislation, the premise operator, has to ensure that whoever does that risk assessment is competent to do so. Now obviously in enforcing this legislation, the fire service tend to look at risk type buildings, or the sort of buildings where there's likely to be a higher risk, so something where you've perhaps got sleeping accommodation in combination with a commercial use, the sort of couple of flats over the top of a fish and chip shop, that sort of thing. Other areas where there's known to be a high level of risk, something like residential care, where you have the issue of can we effectively get people safely out of the building in the middle of the night, and also issues in terms of everyday day-to-day activity. A lot of the prosecutions that happen are not simply because the premises is unsafe, but also because perhaps the responsible people haven't actually carried out sufficient risk assessments, haven't paid enough attention to it, haven't done it correctly, and that can quite often be part of the prosecution as an offence in itself alongside everything else. A lot of the offences that get into the press are actually related to things like post-fire scenarios where an investigation has shown that there were shortfalls. Now there always does have to be an element of in reality, how much do we gain from hindsight and how much could have been predicted? And in taking a prosecution, the fire service will take that into consideration. So a couple of cases, again, to give you an idea of the sort of issues that we tend to see, what happens, and the implications of the prosecutions. So the first one, a national chain of fashion retailers, they had a fire in their, if you like, leading store in Oxford Street. The actual fire itself involved an awful lot of firefighters, an awful lot of fire engines. It disrupted trade to the surrounding shops for a considerable period of time. So a lot of the claims running alongside the prosecution were building up, whether it was insurance companies or whether it was individual retailers trying to get back some of their potential losses. But the retailer was fined £400,000 following that fire. And the breaches there that were identified were that some of the escape routes were blocked by storage and that there was this insufficient staff training to adequately deal with the fire situation when it occurred. A second example, a landlord prosecuted when a fire occurred at a 3-storey house which was made up of 3 dwellings, so it was flats. On that instance, the breaches that were identified was that the fire alarm wasn't working. There was a failure to test the alarm system. There wasn't a proper evacuation plan. There was a failure to provide firefighting equipment, and fire doors didn't close properly. Now, it's important to note in this particular case that as far as the regulatory reform order is concerned, it doesn't apply to individual dwellings, but it doesn't apply to the common parts of a building that are used to access those dwellings. So these issues were about the common areas that were covered by the regulatory reform order rather than something actually within the dwellings. And in that instance, the landlord was fined £36,000. Okay, so that gives us a sort of an indication how the scale of fines might tend to go. And as you'll see from most of the legislation we've talked about so far, the level of fines is pretty much unlimited when we get to serious offences, but the court, as I say, have to take into account the sort of the arguments we were talking about in terms of what was the impact, what was the potential impact, and obviously, that then reflects on the potential fines. When it comes to things like planning and building regulations, it's perhaps a slightly different situation. There does tend to be a similar sort of emphasis on prosecution, but potentially only as a last resort. Now, planning legislation is about environmental considerations, protecting the environment for future generations, protecting our historic built environment, and therefore they work to the National Planning Policy Framework, which is a much slimmer document than previous guidance used to be. And what we're looking for is compliance with standards that they tend to have in place, either through national policy or through local plans. There are a range of tools open to a planning authority when they're dealing with something that doesn't meet the requirements. And most of the work falls short of the prosecution stage. That really is pretty much a last resort. So there are an awful lot of enforcement notices served that require work to be done within a set time period to get work put right, to get work removed. And if those notices aren't complied with, they become a criminal offence and prosecutable. Stop notices, I think we've probably all come across, where a notice can be served to immediately stop an activity, stop unauthorised development before it gets actually to a point where we've done irreparable damage and irreparable harm. And again, failing to comply with the stop notice is an offence, and that could end up in a prosecution. There are temporary stop notices that tend to fill in while we're looking to do get into other ducks in the row for another element of enforcement or prosecution. And then ultimately, yes, we can go to court, prosecute the person or the body who's breached a notice, and therefore seek redress through the courts. And finally, there is the possibility to serve an injunction again. And again, if you don't comply with an injunction, that can lead to fines and imprisonment. So there's a range of tools there, of which prosecution tends to be one of the last options that's available to us. So a couple of examples under planning. somebody had removed and replaced windows. It wasn't authorised. It was obviously a property that was covered in a conservation area. Individual property owner, so they were fined £200. They were asked to pay costs to the local authority of £1,000, court charges as well, and a victim surcharge of £20, as well as the windows having to be replaced. And another case, a conversion of a property without permission. This was slightly more complex because it was a partial conversion and part of the property had permission, part didn't. The council served a notice to cease the use of the properties and return it back. The company responsible failed to comply with that notice, and as a result they were prosecuted, fined £1,000, cost of £3,400, but they were ordered to pay, and this is a significant issue, £18,300 as a result of proceeds of crime because of the income they gained from these unauthorised flats. And that is something we're seeing as a tendency now, is that when taking a prosecution, it's also being asked to consider the proceeds or the gain that somebody has had from these particular instances so that we can actually look at some form of redress. Right. Building regulations then. Building regulations are made under the Building Act 1984 and associated bits of legislation. They deal with the health and safety of people in and around building. They also deal with accessibility, energy conservation, water efficiency and security. The responsibility under building regulations rests with the person carrying out the work, but ultimately with the owner of the property. Again, with building regulations, there are a range of options of how this can be enforced. So enforcement notices can be served requiring removal or alteration. And again, if the work isn't done under notice, the local authority can move in and carry out the work at the owner's expense. Prosecutions for particularly serious breaches are allowable. Now, up until last year, prosecutions under building regulations were covered under the same provisions as a lot of prosecutions through the court system, where fines were limited on the scale of fines to £5,000 per offence. Anything that occurred after the change in legislation in March last year, actually now there is an unlimited fine under building regulations. And as a result, we haven't seen an awful lot of case law to back this up from that point, but the potential is that it will then be more proportional. And the reason that change occurred was that really for a small domestic type project, a £5,000 fine for a small builder carrying out work might be a significant amount of money. For a very large construction project, multi-million-pound project, it was a ridiculously small amount for a contravention. So to be able to make the fines more proportional, not only to the work and the development, but also the potential impact of the contravention, makes far more sense. Local authorities still do have an option for an injunction under building regulations, normally as long as they haven't attempted one of the previous actions before, but to be honest, injunctions in building regulation work are extremely rare. So a couple of building regulations cases, but bear in mind that these were before the change of legislation that brought in unlimited fines. But what did happen previously is that each particular case, there may have been several offences or breaches of the building regulations. So in this case, you can see here, actually the builder was prosecuted for 26 separate offences under the building regulations relating to one property, one project, which was converting a conservatory to an extension, putting in new dormer windows to an existing loft room, and some internal alterations. That resulted in 26 offences, which was one of the reasons that this case went through the court process, because obviously normally these things would be dealt with under enforcement notices or by some form of negotiation to get to a resolution. Builder is found guilty at the Magistrates' Court, fined for the breaches, ordered to pay costs to the council and a small victim surcharge. But interestingly enough, he was also issued to pay compensation to the homeowner and that again up until more recently is something that didn't necessarily get attached to building regulation prosecutions. A second case, somebody committing a couple of offences under the building regulations. They were identified as an issue because of as a multi-agency operation. There were options there to look at how this could be put right. The council made repeated attempts to engage with the individual to get the work put right, so in the end had to go to court. Found guilty of 10 breaches of the building regulations and received fines of 1,400, paying costs of 2,784, and again to engage with the council to put right the breaches of the legislation. Now in reality, as I say, these cases, this couple of cases were before the legislation changed about the level of fines. Most of these instances now you would expect to go into court and get much higher level of fine for these particular contraventions. And then I did briefly mention earlier on that obviously alongside these criminal offences there's usually somebody in the process who suffered damage, and as a result they are entitled to look at suing the perpetrator for compensation. It's not always necessary to go to a civil case, as can be seen from a couple of those instances there. If somebody's convicted in the criminal court, they can be ordered to pay compensation for loss and damage, and therefore using a criminal compensation order can get the compensation without having to go through the civil case. But if that's going to happen, then the injured party needs to detail the losses and advise the prosecution when it goes to court so that they can take that as part of the case. And obviously the court, when looking at compensation, will look at the offender's financial position, the ability to pay, and issues like that, and obviously what is the appropriate level of compensation to the victim. And of course a compensation order attached to a prosecution is obviously dependent upon the guilty party actually being successfully prosecuted. Right, I'm going to try and pick up on some of the questions that have come in. Now I've got quite a lot of issues dropping through about and loads of you telling me yes you can still hear me, so that's really positive. Right, how many prosecutions in the construction in the last 2 to 3 years have been for corporate manslaughter? The answer to that is not very many, a handful or so. They tend to make the press when it actually happens, and particularly what you can do if you're really interested in seeing how these things flag up, if you go onto the Health and Safety Executive's website, you can sign up for updates of any prosecutions they've taken, but it also then flags up similar prosecutions in the sector, so that will give you a view of where they are. As I say, they tend to be high-level cases having had fatalities, and fortunately we don't get a huge number of fatalities within the construction sector. Right. Why are asbestos regulations not applied to domestic properties, especially rented properties? I obviously can't really comment on government strategy and proportionate, but it is down again to who are we looking to hold up as a guilty party. And then regarding building regulation enforcement, once you're entitled to building owner is legally responsible, isn't it unfair when an unscrupulous builder could be commissioned yet the innocent owner is legally responsible? There is a degree of that not necessarily being fair. The prosecution will be against the person carrying out the work. That will normally be the builder. It could be the owner if they've employed a lot of trades direct. The prosecution, as you've seen from the cases I've shown, will impose a fine on the guilty party, will usually ask them to pay reasonable costs of the prosecution, and there is a potential, particularly in the smaller end of the building market, that a smaller builder, by the time he's paid the fine, by the time he's paid the costs, has very little ability and very little finance left to actually try and put the work right. So actually a prosecution can get to a stage where it's not necessarily resolving the situation. That is a difficult one, because then obviously what happens then is that the local authority trying to get the work put right have to serve an enforcement notice on the owner, and they then have to carry out the work. Now the owner at that point probably will be taking a civil action against the builder at the same time to recover the costs of doing that work from them. but it does lead to this issue of trying to get things sorted. And one of the other issues that quite often happens with a building regulation case is that when it goes to court, if the builder at that point has got such a poor relationship with the owner that they can't physically agree to put the work right, which quite often happens if something's gone wrong, then in reality one of the defences the builder will put forward is that he's not actually able to go back onto the site. The client won't let him back on the site to resolve the work, and then unfortunately, yes, it falls back to the owner. So the owner will be responsible and will have an enforcement notice possibly served on them. They will then have to take civil action to recover any costs from the actual contractor. Right, where are we? Working as for a large local authority, our commission works that are sometimes notifiable as an individual. What responsibilities do I have under CDM as the principal designer? Obviously, in reality, what you're doing as the local authority is engaging in that process as a corporate entity in terms of the design, and normally within the local authority structure it will have a degree of indemnity of people acting on behalf of the local authority, but you still have an individual responsibility, and obviously if you act negligently or recklessly, they can still be come back upon you in that instance. Okay, are there any other questions? Anybody else got any other issues? As I say, I do apologize that we've had some technical difficulties today, and we will work on perhaps doing these from a different location, because I've been trying to improve the broadband here for an awful long time. So apologies for the technical details. If you have dropped in and out, this webinar will be going as a recording on our YouTube channel, so you can pick it up. And at the same time, if you want to, you know, tell your friends and colleagues where they can go and see it, so much the better. Right, what are we doing next? We've got some webinars coming up. Our normal technical webinars continue about once a month, and the next technical one is on the 20th of April, looking at the CDM regulations actually, and how they're actually working in practice 1 year after the changes came into effect. But in between that, we're running an extra webinar on the 13th of April for anybody who's looking at applying for membership of the association or looking to upgrade their membership of the association, to actually give some hands-on information to demystify some of our application process. So that's happening on the 13th of April. Slightly different to the normal format. It will be at the end of the afternoon rather than the first thing in the morning. That's because of other commitments here, to be perfectly honest. But again, if you're not thinking about membership yourself, if you're already a member, please tell your friends and the colleagues. As with all of our webinars, they are free to access. If you need any more information about webinars, it's cbuilde.com/webinars. If you need any other information purely on anything we do, please go on to our website or contact anybody here at any time, and we'll be pleased to try and help you with some advice. What I will do is, although there's a couple of questions just flicking through here now, what I'll try and do is publish these as frequently asked questions on the website to go alongside the recording, so that I can give a little bit more consideration, perhaps a little bit more of a detailed response to some of the specific issues. Okay, thank you very much for joining us today. Apologies for some of the tech issues, but hopefully it didn't spoil the webinar too much for you. Thank you.